Good evening. Welcome to this evening's webinar, What's New with Tax Rules and what they mean to you, led by Charles Rotblut of AAII. A handout of the presentation is available under the Handouts panel of your GoToMeeting control panel, located on the right-hand side of the screen, as well as instructions on how to operate the control panel on your device. If you have questions for our speakers, please submit them using the questions panel of your GoToWebinar control panel. Our moderator will select questions submitted and read them aloud for the benefit of all watching the broadcast. If you experience any issues with the audio or video of the webinar, please consult the instructions on how to change your device settings or consult the GoToWebinar's website for support, www.gotowebinar.com. A replay of the presentation will be available tomorrow on AAII's YouTube channel, along with links to this evening's handouts and to some of the resources discussed. These links will be sent to your email address. Now, sit back, relax, and enjoy this live presentation. Take it away, John and Charles.
Well, thank you, Harry. Welcome to our live event tonight, in which we will examine what the many new tax rules mean to you as an investor. My name is John Bykowski. I'm the president of the AAII, and I will serve as the moderator tonight. The American Association of Individual Investors is an independent nonprofit group, and we're here to help individuals become effective managers of their own assets through programs of education, information, and research. So if you have any questions, please put them into the questions pane, and I'll do my best to pass them on to our speaker this evening. We have a very special guest tonight, Charles Rotblut. Charles is the editor of the AAII Journal, and he heads up the VMQ Stock Service. Welcome, Charles.
Good evening, John.
It's great to see you, and I know you've been with the association now for over 10 years, and our members probably have read many articles by you, and they've seen you appear at our investor conferences, and as well as even on the news channel quite a bit, talking about things like the sentiment survey. Let's spend a few minutes here before we get started tonight, letting them get to know you a little better. And normally, you know, you're kind of known for wearing a bow tie, but I see you're not wearing one tonight. Is there any history behind that?
Well, you know, it's a little casual, I figured, sheltering in place, but the bow tie was my wife's idea. She saw a friend wearing one, and I told her, if you buy me one, I'll wear it. She bought two. So, you know, as you know, being married, after a while, we learned to take hints. So she deserves all the credit.
I know that, you know, basically the shelter in order has been in place since March 17th. And I know March 17th because I think, well, at least the association one is a special meaning for you. How have you and Marnie been coping with being stuck at home together?
We're doing pretty well. You know, it's a little bit of a change, but it's doing pretty well. Getting used to, you know, she's getting used to my work habits. But, you know, I will say the commute's a lot shorter.
That's very good. Well, March 17th was your birthday, if I'm not mistaken, is it not? Or
this is true. There's three things that are certain in life: death, taxes, and me wearing green on St. Patrick's Day.
Well, you'll be giving us more information about taxes, but I also, before our conversation here tonight, I noticed there was a poster behind you. It looks to be a cycling poster. And my understanding, and perhaps you can correct me here, is that you actually, not only do you hold a cycling record somewhere in the state of Texas, but also you raced against Lance Armstrong?
I did. When Lance was an amateur, I actually was in a few races with him. And back when I was racing in the early 90s, if you were just active on a bike, particularly in the Texas area, Austin, San Antonio, Houston, there'd be occasions you would just run into him. So I will say my talent level was nowhere near Lance's, never at that level, but I did have a chance to be in a race against him, and the results for me were not favorable. We'll just say that.
I think our members are quite happy that perhaps your cycling career did not take off, but your investing career did. So with that, one more guarantee I hope you could do for us. I know when it comes to government programs and government dictates and whatnot, they are a tremendous fan of acronyms. And whether it's the CARES Act or Secures Act or RMDs or whatever they might be, can you make a guarantee that tonight when our members leave this webinar presentation, they will master those things and be able to talk about them comfortably with their tax accountant and their friends?
Absolutely.
Very good. Well, I'll be back here listening for questions, and if anything comes up, I'll let you know.
That sounds great. Thank you, John.
You're welcome.
Good evening, everybody. I realize taxes is not the most exciting subject, but if you don't pay them, bad things happen. So we're going to talk about the tax law, try to keep you out of hot water with the IRS, and try to make sense of some of the changes that have happened this year. And before I start, I want to point out that I'm a guy who writes about taxes, but I'm not a tax professional. I did start my career working for a CPA, but that was doing business valuation. So if you have a question about your personal tax situation, I would encourage you to spend the time and the money to meet with a tax professional. The little bit of time, the little bit of money that you might pay for doing it certainly pales in comparison to the pain of having to go through an audit if you do something wrong. Now, the reason why we're holding this webinar is this month we published a tax update in the AAII Journal. I've been editor for about 10.5 years. There have been a couple of occasions when we've had to run an update, say in January or March, because there's a late calendar year change in the tax law. We've never had to run a mid-year update in the whole time I've been editor. All streaks come to an end, and such as this streak. We've had a lot of tax law changes being made this calendar year, even though we're only in May so far. And so I thought it was important and would be useful to kind of go over some of the tax rule changes, particularly those that apply to individual investors. So what have those changes been? We can group those into three big things. There's the Secured Act, affects things such as inherited IRAs, RMDs, IRA contributions. There's the CARES Act, which affects RMDs, required minimum distributions, charitable deductions, withdrawals, and the stimulus checks. And the IRS has made its own changes. Now, I don't know who does branding for Congress, but to come up with acronyms that suggest the Secure Act and the CARES Act in massive bills that aren't necessarily viewed by everybody as being caring or securing, I have to give credit to whoever handles the marketing for them. So let's start with the IRS. They actually have a lot of useful information on their website. If you go to irs.gov/coronavirus, you will find details on the various changes to the tax rules, some of the changes that have applied, including the changing deadlines. Now, not everything that's changing with the tax rules as it relates to the coronavirus and as it relates to the CARES Act is on this page. You have to be a little bit of a sleuth and you have to know where to look. And also you have to be a little bit versed in IRS-ese as opposed to legalese. But there is a wealth of information on this page that lay people can read and can access. Now, one of the things the IRS has done is they've shifted a lot of deadlines. Your 2019 federal taxes have now been pushed back to July 15th. And I want to emphasize federal taxes. Here in Illinois, we have state taxes. My mother-in-law's first quarter estimated taxes for 2020 were still due on April 15th. So if you're in one of the many states that has a state income tax, I encourage you to check with your state regulators and see what they have or have not done with their state deadlines. My understanding is some have moved their deadlines, some haven't. So I encourage you to make sure you understand what has and has not changed for your state and for your locality if there's taxes where you, in terms of the town or municipality that you live in. Now, it's both first quarter and second quarter taxes have moved to July 15th. The deadline for 2019 IRA and Roth IRA and health savings account contributions have also moved to July 15th. So if you haven't maxed out your IRA contributions for 2019, your traditional IRA contributions, and you still wish to make contributions to that, you can. There is a caveat for a traditional IRA or for an HSA, because they do affect your adjusted gross income. If you've already filed your tax return for 2019 and you're continuing to make contributions to those accounts for the tax year 2019, I want to be very specific here, you will have to file an amended return. It's not a very big deal, but what it means is you'll actually be owed a bigger refund, or if you pay taxes, some of the taxes you've paid, you won't owe as much and you'll get a check from the IRS. If you've made a Roth IRA contribution for 2019 and you've already filed your 2019 taxes, you will not need to file an amended return. The reason why is it doesn't affect your adjusted gross income. Now, if you're trying to decide, well, I haven't maxed out 2019, but should I then do 2019 right now or 2020? The rule of thumb I would give you is there anything that could happen in 2020 that would cause you to violate the salary caps on contributions to IRAs? If so, you may want to consider maxing out your 2019 IRA simply because that year's already done. So it's a one consideration. But again, you still can make contributions, but if they're to a traditional IRA and will affect your adjusted gross income for 2019, you will need to file an amended return for 2019. Now, the extensions, you do not need to file an extension if you file your 2019 taxes by July 15th. So if you haven't filed your 2019 taxes yet, and you do so by July 15th, you don't need to file an extension. If you choose to wait until October, then you do need to file an extension. Now, with your state taxes, again, if you have a July 15th deadline, I would check with your state to see what their specific rules are regarding extensions. I cannot tell you what each state is doing, but I do know for federal, as long as you file by July 15th, no extension request is required. So let's start with the CARES Act, the most recent changes to the tax law. And it's called, we're talking about acronyms, it's actually called the Corona Aid, Relief, and Economic Security Act, aka the CARES Act. So again, good branding by the government. So what's in the CARES Act that affects many of you? Well, one are the famous stimulus checks. Many of you might have received them. Some of you may have not. And I'll go over what to do if you have not. But the stimulus was $1,200 per person, $2,400 for married couple, plus an additional $500 for each dependent that had a Social Security number. There were phase outs, $150,000 for married couples filing joint returns, $75,000 for singles. The phase out was $5 for every $1,000 your adjusted gross income was above these limits. So it basically meant that if your adjusted gross income was above $198,000 for joint filers or $99,000 for single filers, you did not receive the check. Now, there is a little kicker to this. It was based on your 2019 adjusted gross income. If you had not filed your 2019 returns, it would have been based on your 2018 tax return. So depending on which tax return you had filed with the IRS, that is the return they use to determine whether or not you got a stimulus check. Now, there's a few notes I want to point out about this. The first thing is the tax itself is technically, the stimulus check is technically a rebate on your 2020 tax returns. So even though it was based on your 2019 adjusted gross income or your 2018 adjusted gross income, if you hadn't filed your 2019 return yet, it's actually a credit on your 2020 taxes. So the way tax experts are interpreting this is that if your adjusted gross income is actually lower in 2020 than it was in 2019, you could potentially get an additional stimulus check, meaning that if you didn't hit the limit of $2,400 or $1,200 and your income dropped, your adjusted gross income, you could potentially on your 2020 tax return include a reconciliation and get more money back. Now, let's say it's the other flip side. Your salary goes up this year, and all of a sudden you realize you've gotten more stimulus money than the CARES Act suggests you have. Well, the tax experts, it's not just a Kiplinger's tax letter, other tax experts have reached the same opinion that you will not need to repay it. In other words, you get to keep the money. Now, I want to stress, I have not seen any firm guidance from the IRS. So this is scuttlebutt. But the consensus view right now is you get to eat your cake, you get to have your cake and eat it too. Meaning that if your salary drops, you could potentially get more stimulus money. If your salary increases, you get to keep the excess money. But we do want to wait and hear from the IRS and actually get firm guidance. And because there have been so many changes, and when you add in a pandemic and the understaffing that has occurred at the IRS, not enough guidance has been given on all these things. Now, if you haven't received your rebate, you can go to this URL. And I'm not saying this is set in stone, but I've heard that if you type in your address in all caps, you get a better answer. The reason why I do this, I noticed this with my mother-in-law, and my father and mother had the same experience. Because they're retired and they pay estimated taxes, the IRS claimed not to have their bank account information on file. So even though my mother-in-law's tax payments are made through direct withdrawals out of her checking account, the same thing with my parents, the IRS acted as if they didn't have their bank account information on file. For paying the stimulus checks, what it appears that if you were getting refunds deposited into your bank account, the IRS had your bank account information on file, but not if you're filing estimated taxes. So if you think you're owed a stimulus check and you haven't received it, you can go to this website, see what the status is. It's possible by now a paper check has been mailed to you or is in the mail, but you can go to this URL and check it. Now, let's go to RMDs, because in our update to the tax guide, this has been where a lot of questions have come in. How are RMDs being handled for 2020? Because the CARES Act waived them. In other words, if you're required to take a minimum distribution, RMD stands for required minimum distribution, you don't have to take any this year. You're off the hook. No RMDs, no taxes paid. And if you have an inherited IRA, I've heard several tax experts say that also applies to inherited IRAs. Now, inherited IRAs are different than traditional and Roth IRAs, and a little bit later in this presentation, I'll explain some of the nuances that make them different. But the way the rules being interpreted is if you have an IRA, no required minimum distributions need to be taken this year. Now, if you've taken an RMD this year, you have 60 days to roll it over to another IRA or put it back. And there's several nuances to this, and we're going to get into it. But one of the nuances is if you've taken your RMD and you had taxes withheld, say you asked your broker to withhold 10%, 12%, 22%, whatever your tax bracket is, and say they withheld it. And we'll use an easy number. Say they withheld $2,000, just a nice round number. If you go to roll over that distribution, you then have to pay that $2,000 out of your pocket. In other words, you can't dip back into your IRA and pull out the $2,000. You need to find another source. So I realize some of you are thinking right now, well, now I'm out $2,000. You then, when you file your 2020 tax return, you can then claim back that $2,000. So it's basically that you prepaid $2,000. When you do your taxes, you'll get the $2,000 back as a refund. Now that only applies is if you had taxes withdrawn from your withholding. If no taxes were withheld from, taxes were withheld from your required minimum distribution. If you took the full RMD with no taxes withheld, this will not apply to you. Now let's get into some of the questions we have on it. There's a 60-day window for rolling over IRAs. Excuse me, for rolling over RMDs from IRAs. But because of the CARES Act, they've now extended that 60-day window to July 15th. But there's rarely anything that's straightforward and simple with taxes. So here's what happens. If you took your RMD after February 1, you have until July 15th to roll it over or put it back into your IRA. The way the 60-day window works is 60 days prior to July 15th. So ballparking it, if you took your distribution on February 1 or afterwards up till approximately May 16th, you have until July 15th to put back your IRA or roll it over. To put your RMD back in your IRA or roll it over to a new IRA. After that, any 60-day window ending after July 15th now holds at a 60-day window. And so if you took your tax distribution in February, it seemed at first when you read the tax law, the CARES Act, that you're out of luck. But several tax experts have said that you can now, it does apply, and there's an IRS notice. I said before that you have to know where to look on the IRS website to find some of this stuff. One of the things is find their notices. And you'll see this notice on here. Notice IRS Notice 2020-23. If you go to it, it's a lot of legal jargon, a lot of tax jargon, but it doesn't say anything about required minimum distributions. But several tax experts are interpreting it as applying to all RMDs taken after February 1. And they're saying you have until July 15th to put it back in. A couple members have asked me, well, I took my RMD in January. What happens? Right now, unfortunately, you're out of luck. You took the distribution, you have to pay taxes on it, you can't put it back. I've heard scuttlebutt from some tax experts that they may make a fix to it at some point this year. I have not seen any fix to it. My suggestion to you, if you're in that 1 month loophole, I would call up your congressmen, your senators, your representatives, explain the situation and put pressure on them. That's really the only thing you can do, because as the rules stand right now, you have to pay taxes on it. But if you took your distribution on February 1 or afterwards, you're okay. So I realize it's a little questionable, a little tough, but that's how they're laying down the rules right now. The other thing about rollovers is you're only allowed one per 12-month period. So once you take money out of your IRA and you go to put it into another IRA, you can't do it again for another 12-month period. So if you took an RMD distribution in February, you took a second one in March, and then you realize the CARES Act came out, you can only put one of those required minimum distributions back into the IRA or roll it over. The other one you owe taxes on. And for this particular tax rule, if you don't like it, you can blame the Bob Rows. Several years ago, they abused the law. They took withdrawals from both of the IRAs, actually a few different IRAs, and really played a shell game. Taking out one IRA, rolling it over to another, try to claim it was legitimate. I think they actually were over the 60-day limit on one or two withdrawals. They ended up in tax court. Tax court looked at it, and they said right then and there, not only did you guys violate the tax rules, but we're now restricting rollovers to one rollover per 12-month period. After the tax court gave that ruling, the IRS instituted the rule and made it formal. So if you do not like the 60-day rule, this rule of one rollover, if you do not like this rule of one rollover per 12-month period, you can blame this couple, because they're the ones that led to the tax court ruling that led to the IRS guidance. So what is this rule? So on a 12-month period, funds withdrawn from an IRA are not taxable if you put them back in the IRA or you roll them over within a 60-day period, a calendar day period. And it's limited to one again per 12-month period, but it's also one per person. So if you take one out of your IRA and roll it over, and then your spouse takes one and rolls it over to their own IRAs, that's okay. Trustee to trustee transfers are allowed as well. Again, this is tax speak. So say you have your IRA and you have it with Fidelity and you roll it over to Vanguard and you decide, you know what, I can get a really good deal if I move it over to Schwab. So I just said roll over, and I should correct myself. If you transfer it from Fidelity to Schwab, and then you transfer it, say, from Schwab to Vanguard, and then you transfer from, Vanguard to, say, Robinhood or whoever you like, those transfers are allowed. A transfer is when you directly move it from one brokerage to another. A rollover is when you take the money out of your account, you have possession of it, and then you put it into a different account. So I know it sounds close, rollover and transfer, but in tax law speak, they have very specific meanings. If you roll over your 401k to an IRA, that does not count against a 12-month rule. So you can roll over your 401k to an IRA, then take a 60-day distribution and roll it over within 60 days to a new IRA. You could actually do that. Roth conversions also do not count against that one per 12-month rule. So again, I realize it's confusing. We have several things going on here, but here's what you have to remember. If the money's taken out of your account and you're taking possession of it, that's the 60-day rule. If you move it directly from one account to another, or you do a 401k rollover, or you do an IRA Roth conversion, that does not set off the 12-month rule and a 60-day window. So another thing you can do because of the CARES Act is take actual withdrawals from your portfolio, from your IRA. You're allowed to withdraw $100,000 from your IRA, and you have 3 years to pay this back. Now, it's interpreted by some financial planners as an interest-free loan from your IRA. And technically it is. There are restrictions on whether or not you can do this, and I'll get to that in a second. The way this works is you can take up to $100,000 out of your IRA. For each of the next 3 years, you're required to pay the taxes on that withdrawal. So a prorated amount in year 1, a prorated amount in year 2. You get to year 3, you put the money back. Well, I just told you it's tax-free, but I've also just told you you've paid taxes. What happens in the 3rd year, you put the money back, and then when you file your tax, then you file an amended return for years 1 and 2. So you get your tax you pay on distribution back, the prorated amount back, but you have to file the amended return. Now, should you take the withdrawal from your IRA? The answer is only if you have no other choice, because if you're taking it from your IRA, you're losing out on all the growth that you could have by leaving it on an IRA. So in general, not just for this, in general, for those of you, particularly in your working years, we view taking money out of an IRA, a hardship loan, as a last resort. And if there's any way you can avoid doing so, because the long-term growth of having it in an IRA or 401k is so important for your future. But let's say you have to take it. What situations can you do it? Well, it has to be a coronavirus-related expense. One, you have to be officially diagnosed with the coronavirus. You actually need a medical test done showing you that you've been diagnosed with it. And it has to actually be a diagnosis that fits within the CDC's, the Centers for Disease Control and Prevention's guidelines. So for instance, I had a friend that had coronavirus. She couldn't get a test because tests are short. So she had it, but she may not have been able to qualify for this. If you have a dependent that's diagnosed with a coronavirus, you can take, and you have to care for them, you can take the money out. If you have to take care of a child because child care is unavailable to you because of coronavirus, it applies. Or if you've been furloughed, or if you own a business and your hours and your business has been adversely impacted by the coronavirus, then you can qualify for it. So these are the parameters that within the CARES Act that allow you to take that money out. Again, we would encourage you not to withdraw it unless you run out of options. The other thing that CARES Act has is more generosity on charitable donations. And there's two aspects for this. And I will say you cannot double dip. You have to choose one or the other. The first is a $300 above the line deduction on charitable donations. So what does this mean? Well, what it means is it goes above where your adjusted gross income, your AGI, is calculated. In layman's terms, if you take the standard deduction, you can still deduct $300 off your 2020 taxes. In other words, you can write off $300 of your charitable donations this year and take the standard deduction. So if you're giving to charities and it's a qualified charitable organization, keep track of your receipts, and you may actually qualify for this. If you've been saving to make a big donation in 1 year, this may be the year to do it. Typically, for big donors, the IRS caps the amount of deductible donations at 60% of adjusted gross income. This year, they've removed that cap, so effectively, you can deduct charitable donations equal up to the total of your adjusted gross income for this year. And I realize for a lot of people, that's a huge charitable donation. But we do know under the 2018 tax cuts, under TCJI, the Tax Cuts and Jobs Act, it actually makes sense if you're seeking to take the charitable donation to actually group them up in a single year and take a bigger donation. And so if you've been following this strategy, this may be a year you may want to consider doing it if you actually meet this threshold for the 60% deduction, or the removal of the 60% cap on deductions. Okay. Well, let's move on to the Secure Act, which is actually a big act, not just covering retirement, but a lot of aspects of investing. But we're going to cover the factors of this that directly relate to many of you individual investors, particularly many of you who are retirees.
Charles,
The big thing, yes.
can I interrupt
Yes,
for a couple questions if you don't mind?
Absolutely.
So in regards to I see a number of questions coming up regarding the stimulus check and whether
Yes.
or not it's taxable.
Sure. And I'll actually go back to that. So the stimulus check is, I'll go back here for it, if people don't mind this, is actually a rebate. So it's not taxable. So it doesn't count at all against your 2020 tax income. It's basically as if your taxes have been reduced for this year. And if you didn't owe any taxes, it's basically a negative tax rate where the IRS is just giving you money.
And then follow-up question or different question, and you may not be able to answer this. For a surviving widow or widower whose spouse died in 2019 and has already filed taxes for 2019 as a married joint, should they expect to get $1,200 or $2,400?
That's a really good question. I have not seen that asked anywhere. I don't know. But I'll tell you what, the person who asked that, my email is charles@aai.com. I will see if I can get an answer to that. I actually do not know what the answer to that question is. I have not seen that raised.
Okay. A couple of questions in regarding to, so stimulus checks won't count as higher income in 2020. And you have, I think, a slide that's going to indicate where to contact people if they haven't gotten a stimulus check. Is that correct as well?
Yeah, and the slide deck will be actually available to everybody afterwards, but this is what I'm showing on my screen is actually the link. But if they download the presentation, they'll see the link there. And as I said, I don't know why, but I've heard that if you type in all caps, it works better. And for those of you going to that site, you'll see something about the tool being used, authorized for government use only. If you see that window, just hit OK. I don't know why it's there, but just hit OK and don't worry about it.
Very good. And then in regards to estimated payments on 2020, is that going to be covered later, or do you want any additional color on that? So when are 2020 estimated payments due?
So they were at first quarter and second quarter estimated taxes are actually due on the 15th. So typically, because second quarter taxes are usually due on June 15th, for federal they're due on July 15th as well. But again, for those people living in states where there's income taxes, check with their local governments. For instance, I do not think that Illinois has moved their estimated tax deadlines yet for even second quarter. I know they did not do it for first quarter.
And if someone wants to do a Roth conversion for 2020, do they need to wait till after July 15th, or can they do it now?
They can do it now. And one of the things I'll say about Roth IRA conversions is since the market's off its high, that's actually the best time to do a Roth IRA conversion because the IRS doesn't care if you move over 100 shares, 150 shares, 200 shares. It only cares about how much money you move over. So when the markets are off their highs, you actually get more bang for your tax buck. So if your stock, say, was at 50 and now it's at 45, if you had a certain dollar amount you were planning on moving over, you could actually move over more shares for the same dollar amount. So when the market eventually rebounds, and hopefully your stock will with the market, you'll actually come out ahead than if you wait. So for those people in general who are thinking about Roth IRA conversions, plan to do so early in the year and then keep an eye out for a market downturn and take advantage of it because you'll get a tax savings by doing so.
And so if someone's already filed their taxes for 2019 and they want to do a Roth conversion, they would have to amend, or what would they need to do?
So the Roth conversions, my understanding is the Roth conversions have to be done by December 31st. So you wouldn't be able to do it for December. You wouldn't be able to do it for 2019. You can do it for 2020, but it's a calendar year deadline for doing the Roth IRA conversion. So even though you can put money in a Roth IRA and put money in an IRA and have it count towards 2019, my understanding is that December 31st deadline for doing a conversion for 2019 was not changed.
And then two more questions on Roth IRAs, and then one or two on RMDs here, but then I'll let you continue on.
Sure.
So I retired on November 7th, 2019. Am I eligible to contribute to a Roth IRA?
So I'm sorry, you retired. What was the date you retired on? It was
last year.
November
7th last year.
So they would actually be able to make one for 2019 because the key is they have to have earned income. And so since it would be counting for 2019 and they had earned income and the deadline has not hit yet, they'd be able to do so. And that's my understanding. If they want to double check, they can check with a tax professional. But my understanding of the tax law is that's the way it would work. But I would probably encourage that person to just double check with someone they know who's a professional to ensure that's the case.
And I'm guessing probably would be helpful that we'll put some links to Roth IRA conversion information on our show notes. But then just one general question is there still income limit on participation in Roth IRAs?
There is. That has not changed. I couldn't tell you what it is off the top of my head, but there's still an income limit. It's actually should be in our tax guide.
Okay. And when it comes to RMDs that you can put back, are the rules the same, whether it's an inherited IRA or a 401 or a 403B or 457?
So my understanding is with IRAs, my understanding is from what I've heard from several tax experts is you can do it back to an IRA. It should actually also, with the 401ks, I would check with the employer, the plan, and same with 403Bs, and see exactly what the rules are with taking distributions and how they treat those distributions. I don't want to say for sure because different organizations have different rules. So I would check with the plan sponsor in that situation to make sure you understand what their rules are and how they actually view the withdrawal.
Okay, very good. Well, I'll let you continue on, and I'll be monitoring the questions panel for more questions.
Sure, absolutely. And again, thanks, John. And again, if more people have questions, please feel free to ask them. I'll try to answer them to the best of my ability. I'm going to slide forward here to the Secure Act. So this was passed earlier this year before the CARES Act. It was one of the laws that also changed the tax rules. And since we were just talking about RMDs, good place to start. So if you were born on January 1, 2020 or later, you now have until age 72 to take a required minimum distribution. You can still take distributions earlier, but it used to be at age 70 and a half. So if you turn age 70 and a half on December 30th, you're under the old rules. But if you turn 70 this year, you're under the new rules. Now, the interesting thing is they moved back the date for taking RMDs, required minimum distribution. Qualified charitable distributions, which is basically a donation made directly out of your IRA. The age for doing those still starts at 70 and a half. So they're giving you more time to contribute to your IRA. Sorry, they're giving you more time to postpone RMDs, but you can still take qualified these QCDs out of your IRA. So it's actually a win-win for many retirees. And I'll get to how this all plays with the tax rules in a second, because obviously this year there's no RMDs, so I'm sure there'll be questions about the QCDs. But what I want to say is there's no age cap now on IRA contributions. So it used to be you hit age 70 and a half, you can no longer contribute to your IRA. You could do a Roth IRA conversion, and you could do a rollover, say, from a 401k to an IRA, but you couldn't contribute to an IRA. That cap's been removed, but you have to have earned income, meaning you need something other than your withdrawals, your Social Security. You basically have to have a job. So maybe you're doing part-timing, maybe you're still actively working. In that scenario, you could continue to make IRA contributions. Now, let's start getting to these QCDs, because things get a little tricky here. Jamie Hopkins actually talked about this in last month's AAII Journal. If you make a qualified contribution to your IRA, deductible contribution to your individual retirement accounts, and you want to take the qualified charitable distribution, you actually cannot do the QCD. So to make things really simple, say you put in $7,000 into your IRA, and it's a qualified contribution, meaning it deducts off your taxes. You have to then take $7,000 out of your IRA before you can make the QCD. So the way to think about it is for every dollar of contributions, of qualified contributions you make to your IRA, so every dollar of deductible contributions you make to your traditional IRA, you now have to withdraw those before you can take the QCD. And I would actually encourage you to read Jamie Hopkins' article. We'll put this in the show notes to actually, because he explains it in further greater detail than I am about how this rule works. And so I encourage you to read this before you try to do both. There's also new rules on inherited IRAs. And I realize for some of you with bigger estates, it causes problems. Because what it did is it eliminated the stretch IRA. And I'll explain this in a second. But what I want to say is if you're married and one spouse passes and the surviving spouse is the heir, I would encourage to think about renaming the IRA in their name. So let's say we have a hypothetical married couple, Bob and Jane. Bob passes. Jane is the beneficiary named beneficiary on Jane. Jane is the named beneficiary on Bob's IRA. Jane can either take it as an inherited IRA, or she can rename it so that it becomes Jane's IRA. If she renames it as Jane's IRA, then it's treated as her own IRA and she has all the advantages of doing it. If she actually takes it as an inherited IRA, then it falls under the inherited IRA rules, And the key thing to remember, and I'll get into a reason to why this is really important in a few minutes, but inherited IRAs and traditional IRAs are not the same. An inherited IRA is different than, say, a traditional or Roth IRA. And that has actually implications beyond just the Secure Act. But at the bottom of the slide, you'll see here, I have an article quoted, Top Secure Act Provisions. This is the last month's article. This is the article I just referenced, which you want to read about how the QCDs and the RMDs are interrelated and what you need to know about both, the required minimum distributions and the qualified charitable distributions. So for those of you with big estates, this 10-year rule is going to throw a wrench in many of your estate plans. What the 10-year rule holds, that the beneficiaries who inherit an IRA have to completely withdraw all funds within a 10-year period. Now, spouses can sidestep this by putting the IRA in their own name. There are exceptions to it. So the beneficiary is within 10 years of age of the deceased. If they're chronically ill, if they have a disability, or they're a minor, this 10-year rule doesn't apply. But once the minors stop being minors, then the 10-year rule does kick in. And so what this means, it used to be under the old rules. For a lot of people, they took their IRAs and they wanted to actually give the money, say, to their children or to their grandchildren. And the idea was they would pass the IRA to them, and then those beneficiaries could stretch out the distributions over their lifetime, basically extend the life of the IRA. It allowed the money to be in the IRA and grow on a tax-free basis for a longer period of time. The Secure Act took that away and now requires it to be completely withdrawn within a 10-year period. So I realized that, a stretch IRA was part of your estate plan. It's a big issue. So what can you do if you're in a situation where you're really counting that stretch IRA as part of your estate strategy? Well, there's a few things you can do. The first thing is you may want to consider doing a Roth IRA conversion, because that way your heirs will inherit a Roth IRA and they won't have to pay taxes on those withdrawals. Now, the way you want to consider the math on this is your tax rate versus your beneficiary's tax rate, the beneficiaries of your inherited IRA. If your tax rate is lower, and doing a Roth IRA doesn't jack up your Medicare premiums and doesn't increase your Social Security taxes, or if it does and it's still lower than your heirs' tax rate, in that case, it may make sense to where you pay the taxes now on the rollover and you spare your spouses. You could also consider taking an outright withdrawal and then gifting the money to your heirs up to the limits. You could also consider setting up a charitable remainder trust. Alternatively, life insurance and annuities might also offer a possibility. Now, I do want to say I'm not an expert on trust. I'm not an expert when it comes to life insurance and annuities. So if you're thinking about using those as a workaround for the Secure Act, what I would suggest is that you meet with a financial planner, perhaps in the case of a trust, an estate attorney who's well versed in these, and go over your options and make sure you ask as many questions as possible to understand what you're getting into, and then make the decision as to whether or not it's right for you. Of course, the other option is just realize that tax law has changed and realize your heirs are going to have to pay taxes within a 10-year period. Obviously, you could try to lobby your congressional representatives about this, but right now the law is saying it has to be withdrawn within 10 years. And I do want to point out that we are a membership organization. We are not a lobbying organization. So we cannot, AAII itself cannot go in front of Congress on your behalf and lobby this. If you're not unhappy with the law, it's something you need to personally take up with your elected officials. Sorry to break that bad news for you. Sometimes I have to be the bearer of bad news. Now, I also mentioned inherited IRAs are not the same as traditional IRAs. And this also gets into the estate planning aspect because it's not something that's often talked about, but it's something you should be very aware of. According to the Supreme Court, inherited IRAs are not retirement accounts. This was actually in a court ruling. In this case you see me before I'm showing you the case I'm showing you on my slides, there was somebody who had inherited an IRA, filed for bankruptcy, and then went to bankruptcy court trying to argue his inherited IRA was protected from the creditors. In a Supreme Court ruling, they said that inherited IRA assets are not those specifically set aside for purposes of retirement. Therefore, they do not deserve the same protections against bankruptcy as traditional IRA assets do. And now, as the case when it comes to these taxes, there's also a caveat here. After this court ruling came out, an Idaho court ruling said, well, in Idaho, they actually are. Now, if you're trying to make sense of the two, here's how it breaks down. It depends on your state. In many states, inherited IRAs are now no longer protected from the bankruptcy code. The exception is if the specific state you're living in, or perhaps the person who inherits your IRA is living in a state like Idaho, where state law specifically protects the inherited IRA from creditors. So if you're leaving your IRA to an heir and you're worried about potentially them being sued or potentially them having to file for bankruptcy at some point, perhaps they're an entrepreneur, perhaps there's something that might be risky about their financial situation, consider this, and you may at this point want to meet with your state attorney and consider whether or not saying a trust as a beneficiary might be the better option. Again, this is not something I can give you specific advice on, but it's a characteristic of inherited IRAs that a lot of people are not aware of, and it is something to consider as you're making your estate plans. And obviously, we hope that your heirs do not incur bankruptcy, but it's obviously a risk, and I wanted to make you all aware of it. I've given you a lot of overview of the tax law changes. And again, I want to stress, I'm someone who writes a tax guide. I'm not a tax professional. I do talk to tax experts, but the big thing I'll tell you is that if you have questions, spend the time with a tax professional. I realize there's a cost involved. I realize there's a time commitment. But when you fill the tax return, you're ultimately responsible for what's going on that tax return. So make sure that you have your questions answered. And if you need to spend a time with a tax professional, please do. I also know that our membership tends to skew more towards men than women, but we also have women who are in charge of the finances. And typically in most households, it's usually one spouse who pays the taxes. I would encourage you, if you're the spouse that does the taxes, when you do your taxes every year, have your spouse go through the whole tax return. Every year, I have my wife check every aspect of return, all our forms. It's not the most pleasant or fun experience, but A, she has a right to know what's on a tax return, and B, it's a second set of eyes. And as an editor, I know having a second set of eyes is valuable. They might catch a mistake that you missed. It might be a little, you might have misplaced numbers. You might have intended to put in 7.9 and maybe put 9.7, or perhaps you put something in the wrong line. It's a nice way to get errors caught. Now, I told you I'm a tax editor, not a tax professional. So where do I go to get tax information? Here's a list of resources I personally use, and these are open. They're accessible to you. One is the IRS's website, the irs.gov. Even though things aren't always explained in the easiest terms, a lot is, and there's a lot of information on the IRS's website. What I find really useful, if I need to find a particular type of thing, I'll type in what I'm searching for, IRS in Google. So say I want to know something about the coronavirus. I would type in, go to my favorite search engine, Google, or perhaps another search engine, do a search on coronavirus IRS. That will take you to the coronavirus page. It works a lot better than trying to search through the IRS's website. Walter's cooler. If you click on that link, you'll actually get to the tax section. They do a lot of things for professionals, lawyers, accountants, but they do have parts of their tax information that's available to individuals. Mark Lipscomb, who's been a tax expert, has been a huge help to me over the years. We give a shout out to him in every tax guide because it's been a huge help, but you can find information on their website that is accessible to individual investors. I do have an updated copy of J.K. Lasser's Your Income Tax Guide. I buy the book every year. Still not big yellow cover. It's still the size of a phone book. But I do find it helpful to actually go through and find information on specific tax topics. I have the Kiplinger's tax letter. We as an organization usually don't recommend outside tax letters. This is, I just mentioned, it's a resource that I personally use. It's very tax focused. But if you're someone who is a real diehard and you really want to keep track of what's going on in the tax law, I do find it to be useful. I subscribe to it solely because I do the tax guide, and so I need to keep up to date about what's going on. On my Twitter feed, if you click on this, I actually have a list of tax experts that I follow. Now, I don't follow it every day because I'll warn you, some of the stuff's about, you'll see them talk about German tax law or, this tax rule affecting the small business. So not everything's about individuals, but usually as we get near the end of the year, or if I know big tax legislation is coming out, then I'll start going to this. So this specific thing is a list of tax experts who tweet, and they will provide tax information. And so you can click on this link, you can bookmark it, and if you know some tax law changes are coming out, you can actually use it as a resource. I have TurboTax on this solely because I've used TurboTax for about 20 years. Certainly there's competitors, there's H&R Blocks. H&R Block has some. The IRS is now allowing you to e-file if your income's below a certain limit. But as long as I'm listing resources I use, I've been a long-time TurboTax user. Finally, our guide. As you can see, there's a lot that goes into it, and a lot of credit goes to my editors, Gene and Aneen and Ryan, who actually go through the details, trying to make sure what we put in our tax guide is correct. A lot of numbers to go through, and they deserve a lot of credit each year for doing it. But we do put a lot of effort to our tax guide. We do try to provide a lot of information that applies to individual investors. And we do listen when people start asking us, hey, can you do this or can you include that? We do think it's going to apply to a lot of people. We do take requests in terms of how we can improve it. But we also do include a tax planning worksheet to help you get an estimate of what you might owe each year so you can get an idea of what your taxes might be. So I do want to thank you for tuning in. I know taxes are not the most exciting topic out there, but John, if people have additional questions, I'll be glad to answer them.
There's quite a few here, Charles.
Okay.
So let's see here. I've got a couple questions here, and it's regarding news stories where members have heard information regarding deceased people getting stimulus checks. And there's conflicting information as to whether or not that needs to be paid back or not. There's no clawback provision in the law, but IRS is asking for money back. Any color on that?
I've seen the headlines of it. I haven't had a chance to read on it closely. And given you have this gap between 2018 and 2019 taxes and the speed at which this law was passed, I don't have any information, and I do not know if the IRS is going to try and claw back or not. And if they do, I'm not sure how that would work, particularly if someone's actually filed the final return for the deceased. So I think it's something to keep an eye on if somebody's actually in that situation, they had a loved one who has passed, and my condolences if that is the case. But it would be, I couldn't tell you how that's going to work.
Understood. If you don't take a RMD this year, how will it impact RMDs in subsequent years? Number of questions.
Yeah, and that's a good question. I should have addressed that earlier. So, because it also ties in with the QCD. So if you don't take an RMD this year, the value of your IRA will increase by that amount, obviously adjusted for market returns. So your RMDs in all future years will increase. Now, let's say you do a QCD instead of a distribution. There's no tax savings from doing a QCD. So typically, a qualified charitable donation distribution reduces the size of your RMD dollar for dollar up to $100,000. But because there's no RMDs, you're not offsetting anything by taking your QCD. So what happens is your QCD in this scenario reduces the value of your account by the amount, say you take out $10,000, and because the value of your RMDs, because the value of your IRA is reduced, your future RMDs are reduced. So the big thing to think about is how does it affect the value of your IRA? If you don't take anything out of your IRA, the balance of your IRA is going to be higher at the end of the year than it is now, market fluctuations aside, and you'll have greater RMDs going forward. If you have money coming out of your IRA now, then it'll actually be lower in future years. So there's a question as for your RMDs, and if you're close to the tax, if you're close to those tax brackets where you're right between going up or down, or perhaps you're close to Social Security in terms of how much your Social Security is being taxed at, then you may want to do the math and see whether or not it makes sense to do some type of withdrawal this year, or whether it makes sense to do a QCD this year.
Thank you. Very helpful. A couple questions here regarding having income to make a contribution to an IRA. Does passive rental income count, and does being a landlord count for earned income regarding to IRA contributions?
As far as I know, it's earned income. As far as how it applies to landlords, I do not know the answer to that. That was something I would ask a tax professional. That aspect of how that counts as income is not something I could answer, unfortunately.
Understood. I guess since you mentioned you use, I think, TurboTax, the question here was, do you consider filing taxes online to be a safe practice?
I do. It's interesting that they brought that up because I file my federal online by mailing my state taxes. And the reason why is that it costs about $20 to file the Illinois state taxes, maybe a little bit more. And obviously a stamp is about 45 cents, 49 cents. I don't know exact postages right now. So it's cheaper for you to mail it in. But approximately 85% of taxpayers e-file. And there really has not been a problem so far with electronic filing. I do strongly suggest that your antivirus software is up to date, that you have a firewall set, that you're taking all the necessary precautions you normally would protect your computer. Now, can I say with 100% that you won't be hacked? No, I can't. But as I said, there's a lot of people filing, and you're not really hearing about it being a problem.
This is a question regarding, does it matter what month of the year is in terms of your birthday when it comes to determining your RMDs, your first RMD? Is it prorated? Is it the full year? How does that come into play?
It's a full year, and it's based on your account. Now, it's based on your calendar year, so it's actually based on the full year. So it really is what your age is at the end of the year. You're 70. It really is your age at the end of the year that determines whether or not you paid an RMD. So if you turn 70 on December 31st, you owe RMDs for 2019. If your birthday was 12/01, January 1, then you're actually considered being in a 2020 tax year. So really, depending on where you fell in that limit determines it. So it has to do with the calendar year that you actually turn age 70 and a half, that when the RMDs start. And now, obviously, with the Secure Act, when you turn 72, if you turn 70 and a half after 2020. Sorry, after 2019.
Understood. When it comes to the new 10-year rule, withdrawal rule, does it apply for Roth IRAs or just traditional IRAs? Inherited IRAs?
To a 10-year rule?
Correct.
It actually applies to both. It applies to all IRAs, so both Roth and traditional IRAs. A 10-year rule. The one advantage about a Roth IRA is even though it's still 10 years, there won't be taxes paid because IRAs, by definition, are paid with or could have after-tax dollars contributed to them.
And just a question asking for clarification on what is the year in which the rule between the 10-year rule versus the old stretch IRA option, what is the first year where that actually comes into play? This is part of the Secure Act, correct?
Yeah, so it goes into effect this year, 2020.
So if someone passed away last year versus, and then you'd inherit it this year, is that how it works, or?
Yeah, so if they died last year, they fall into the old rules.
Okay, thank you.
Mm-hmm.
And I'm not sure if I can explain this correctly. I'll give it a try here. Someone didn't understand how gifting will help inherited IRAs. Doesn't the gift have to come out of the taxable account?
It does, and so the idea is you take them, you take the withdrawal yourself, and then you would gift the money. So instead of actually passing along an inherited IRA, you could actually choose to pay taxes on the withdrawal up to $15,000, and then you give them the money. So instead of passing along IRA assets, you'd pass along monies outside the IRA. And so that would be one way of actually doing it to get around the 10-year rule. Because if you give them, say you give them $15,000, they put immediately in a brokerage account. It's a very tax efficient fund, say like an S&P 500 index fund. Their taxes will be very minimal for well beyond 10 years. So that's where the argument for gifting, taking money out of the IRA and gifting, comes into play with this 10-year rule.
A couple of questions here regarding spousal treatment of IRAs as beneficiaries. Did I see that if your spouse is your IRA beneficiary and is less than 10 years younger, the changes in the stretch IRA is not relevant?
That's my understanding how the rule works. And I will actually refer those people to Jamie Hopkins' article in the April Journal. I believe he discusses that. But yeah, there's a carve out there if someone's under 10 years, is less than 10 years younger than the deceased. And I think the thoughts with the IRS is that they're probably close enough in age and it'll probably mostly apply to older individuals. Now, obviously, we hope everyone lives a long, healthy life, but that's my understanding of the logic, is that it does not apply. But the rule does state that the 10-year rule will not apply if they're within 10 years of the age of the deceased.
And then here it has, if I set up a trust account as my IRA beneficiary, can the trust avoid the 10-year distribution rule?
My understanding is the IRA has to come out within 10 years because it's treated as an inherited IRA owned by the trust. But then the rules for liquidating the trust itself may be different. And that's where you want to speak to your estate attorney about what the rules are for the trust itself, because there may be rules specific to the trust.
And Julia here notes that the IRS, if you get a check in the mail that is made out to a deceased person, the IRS asks that you write void on the check and mail it back to them.
There we go. Now, I can't say what happens if you don't, but that's what the IRS is currently requesting. And as I said, realize when they passed this law, I believe the original bill said they get these stimulus checks out in about, I think it was like 10 days or 15 days. And when I saw in the law, I was shaking my head going, this is not going to happen. And so at the time we had this pandemic occurring, they were also requesting all these issues to happen. And so now you have the IRS basically saying, we goofed, please help us out. And because of the whole current situation.
And I see another member, Robert, here did the same thing. And then what is the divisor for calculating your RMD in 2021? Will it still be based upon your current 2021 age? So you just skip the divisor for 2020?
My understanding is that you'll skip my understanding of this is that you'll actually skip the RMD for the divisor for this year and go to next year because it is based on your age. So I've not seen anything about it. They are redoing the RMD table, so that's gonna make a small difference. It'll change it, but my understanding is I should say this. I have not seen anything that suggests that won't be the case.
And Joyce notes that you need to take your RMD in the year that you turn 70 and a half, not 70.
I thought I said that. Thank you for the correction, Joyce.
And I think a member actually had a note on your article that you did on regarding the tax changes, and there was a number of interesting comments. And one person was grateful that the IRS noted that it'll be good till he's 99 and a half years old, and is considering doing a tattoo. Would you recommend that or not, Charles?
I don't want to recommend tattoos since, if they get till 98 and decide maybe I didn't want to have it. I don't want to be responsible for their choices.
Understood. I have time for a couple more questions here. I know we've gone a little bit past our allotted time. Any concerns you see with entering bank account info on IRS website? Should you just wait for it to be mailed?
I've been doing direct deposit of my refund checks for years. As I said, most people electronically file. As long as everything it is secure, but I can't say it's 100% secure. So my advice, if you don't feel comfortable, then you can wait for the check to come in the mail. But as I said, the e-file rates are well over 80%. Most people do e-file, and you should have your antivirus software up to date, your firewall software up to date. But if you still don't feel comfortable doing so, then don't feel pressured to put your bank account information into the IRS's website.
Well, thank you very much, Charles. I also have a number of members here who are saying great presentation. They really enjoyed the effort you did tonight, as well as the effort that you do with the tax guide throughout the year. So, but before I leave you, I've got a question or two to ask. This is just a quick question off the top of your head. So obviously you and Marnie have been probably spending a lot more time at home. And so when it comes to getting a break from what's going on in the investment world or whatever, do you find yourself reading more or watching more TV?
Oh, that's a good question. Probably, actually, I'm surprisingly watching less TV, I think, because we're so busy here at AAII. Did find time to watch Tiger King. We both did. Found it rather humorous. I would probably say a little less TV, reading about the same right now.
Anything you're reading in particular you recommend to our members here?
Hopefully I'm getting the author's name right. I think it's Lawrence Cunningham. He actually has a book of shareholder letters, and it's letters by it's CEO letters to shareholders. So it's letters from CEOs of various companies. Obviously, Warren Buffett's in there. I'm reading right now about Constellation Software. Morningstar comes to mind. Markle, Fairfax. And it's interesting because you start to see what these CEOs are actually thinking about their businesses, how their views have changed over years, what metrics they pay attention to. So it is something that's really appropriate to someone who's an investing junkie. But yeah, it's a pretty interesting book, and it's interesting to see how the CEOs' viewpoints and how their style of writing does change over time. I should add, though, I am a Berkshire Hathaway shareholder. I do read Warren's shareholder letter word for word every year, so I might be an outlier in that regard.
I think you delayed a trip out to Nebraska this year, is that correct?
I did. I was supposed to be in Nebraska about a week and a half ago, and I was supposed to be in Atlanta, I believe, this weekend, and was going to speak at our Atlanta chapter. And but then again, I was also supposed to take a cruise this spring, and maybe it's a good thing that got postponed.
Well, I know where you'll be next Wednesday, because next Wednesday, I believe you're going to be moderating a upcoming webinar with Derek regarding, I think, he's going to analyze, I think, a stock using a dividend model as far as give you some tips on how to go ahead and do a deep dive on a company. So that'll be our webinar next Wednesday. And also, we have right now a couple other webinars coming up. We have a group webinar, a panel we're putting together with a number of other educators such as ourselves, people like the Chartered Financial Analyst Group, the CFA Group, and there'll be a panel that we'll be putting on to help give information on individual investors and for all on what they should be doing to make sure they keep their long-term investing plans in check. And also, I see we have Kevin Carter, the founder of the Emerging Markets Internet and E-commerce ETF. And do you know anything about that particular presentation, Charles?
I don't. I know he's going to actually talk about emerging markets. I believe he's going to talk about China as well. I've seen a few details about his presentation, but not enough to really elaborate on it. But I understand Kevin's a really good speaker, and I understand it should be a pretty entertaining presentation and informative.
Well, I'm looking forward to it. And I want to thank everybody for coming in, tuning in tonight. Obviously, we have many choices as far as how we spend our time, and we're excited that you chose to spend your time with us. This webinar was recorded, and a broadcast will be made available to you probably shortly, probably sometime tomorrow. An email will go out, and we'll have contact information in there regarding how to get in touch with Charles and how to get information, that all the information that was presented to you tonight. So with that, thank you very much. Everyone stay safe and healthy, and look forward to having another wonderful presentation next week. Thank you.
Thank you, Charles and John.